Hello, I'm Jessica Ryan Keeney. I am an attorney licensed to practice law in the state of California. I am the Department of Child Support Services attorney for two small Northern California counties. And what I'm about to say today is not legal advice. Always be sure to check with an attorney who can evaluate the facts of your case. This is for educational purposes only. With that out of the way, go ahead, like, subscribe, ding the bell so that you get notifications when we upload future content, and thank you for being here. Today's video, we are going to discuss laches as a defense to paying child support to the other parent. So again, this article is not legal advice. It's for educational purposes only. Now, laches is a concept in common law. It's not found in the statute. And it's an equitable concept, and many people think of it like a statute of limitations, but it's not actually a statute of limitations. And below is what some case law has to say about laches. And I'm not going to give the full citation to each of these cases. I'm going to try to put the full citation in the description. Hopefully it'll all fit. That way you can go look up the cases and read them yourself and shepherdize them to make sure they're still good law. So the court in the Parker v. Parker case explained that laches is based on the principle that those who neglect their rights may be barred in equity from obtaining relief. And they're citing City of Oakland versus Oakland Police and Fire Retirement System. The doctrine of laches is to actions in equity what a statute of limitations or what statutes of limitations are to actions in law. And that's Corano Properties of Florida versus Monroe County. And so there we go. We have the court mentioning that laches is in equity what statute of limitations is in actions of law. So that probably has something to do with why people think of it as a statute of limitations, when in fact it's not exactly a statute of limitations. But there are some similarities in that with a statute of limitations, once you reach that statute of limitations, you can't prosecute the case. You can't win if you try to prosecute a case or try a case, and then on a particular matter. And then with laches, the court finds that so much time has passed, the party's been prejudiced, there was an unreasonable delay, and so you can't win on the case you're trying to prosecute or try. Okay, so in marriage of Boswell, the court citing the marriage of, I know I'm going to mess up this name, Calcaterra and Laches, and also citing the marriage of Egdy, held that family law court is a court of equity. Those who seek equity must do equity and have clean hands. Family law cases are equitable proceedings in which the court must have the ability to exercise discretion to achieve fairness and equity. So how does one prove laches? Well, the court in Parker v. Parker, citing Magic Kitchen and Good Things International, held that that in order to prove laches, a defendant must demonstrate three elements to successful assertion of the laches. I'm tripping on my words. The defendant must demonstrate, or the respondent must demonstrate three reasonable elements to successfully assert a laches defense. There was a delay in asserting a right or a claim, the delay was not reasonable or excusable, and there was prejudice. So what does the Family Code say about the defense of laches? Well, Family Code section 219 subsection D reads as follows. In an action to enforce a judgment for child, family, or spousal support, the defendant may raise, and the court may consider the defense of laches only with respect to the portion of the judgment that is owed to the state. And this law took effect January 1st, 2008. And because this law took effect January 1st, 2008, we're only going to look at those cases that were decided after January 1st, 2008. And again, we're only discussing laches as owed to the other parent, although we may see some discussion when we're looking at this in support owed to the state. So I picked out two cases for us to discuss. First is in remarriage of Boswell, and this is a case in which mother and father were married and they had two children. They divorced in October of 1985. Mother got physical custody of the two children, and father was ordered to pay child support of $70 per month per child. Father paid child support for 2 months, then mother disappeared with the children, and when she moved out of California. She changed the names of the children, and she didn't let father know the new address of the children. Father didn't see the children for about 15 years, and after the older child turned 18 and the younger child turned 16, the younger child went to live with father. The younger child then lived with father until that younger child turned 18. 15 years after the younger child turned 18, mother tried to enforce the child support order and sought a judgment against father for $92,734.94. That's a hefty sum. The trial court refused to enforce these child support arrears because mother hid the children from father for 15 years. The trial court specifically ruled that doing this would be inequitable, that the request was untimely, unjust, and that this was just a terribly egregious situation. Now, unfortunately, the court used the Laches defense as part of their reasoning for not upholding these arrears or not enforcing these arrears. So the issue relevant to this article to be resolved here, or relevant to this video, is did the trial court abuse its discretion and apply a faulty legal analysis in making its ruling, and does the defense of Laches apply to this situation? The court affirmed the judgment of the trial court. However, the court found that the trial court did err by employing a Laches rationale as an independent reason for denying enforcement of the judgment. The court, citing the marriage of, I'm going to mess this up again, Calcaterra and Badashk, and marriage of Egdi, held family court is a court of equity. Those who seek equity must do equity and have clean hands. The family law cases are equitable proceedings in which the court must have the ability to exercise discretion to achieve fairness and equity. The court further held the trial court found that mother had been unjust in her unilateral decision to remove father from the children's lives. This was tantamount to a finding of unclean hands. We reiterate our statement in Keith G. v. Susan H. These are some of the dirtiest hands we have ever seen. A little bit of an understatement there that it was unjust, but yeah, those are definitely some unclean hands. The court additionally held, citing Paget v. Paget, as expressly indicated by the trial court, this was terribly egregious. The clean hands rule is of ancient origin and given broad application. It is the most important rule affecting the administration of justice. Equity denies affirmative relief for such conduct, even though it thereby leaves undisturbed and in ostensible full legal effect acts or proceedings which would affirmatively be set aside but for such consideration. We hold that a family court, in the exercise of its broad equitable discretion and upon a finding of unclean hands, may decline to enforce a child support arrearage judgment. The court also held that Family Code Section 291 Subdivision B provides that the defense of Laches only applies to child support owed to the state. So although Laches was not a defense to the payment of child support arrears in this case because they were owed to mother and not the state, the court found that the trial court had broad equitable discretion upon a finding of unclean hands to decline to enforce the child support arrears judgment. So even though Laches is not a defense to paying child support arrears owed to the other parent and not owed to the state, the court can consider unclean hands and use its equitable discretion to refuse to enforce child support arrears. So there's a lot of talk about unclean hands here. What are unclean hands? Basically, it's when one person does something bad And then they ask the court to remedy the wrong or the bad thing that the other person did. And so in equity, when both parties have done something bad and and the party seeking the court's order in equity has unclean hands, the court can consider that and can refuse to make that order. So it's kind of like when a little kid gets in trouble and then they say, yeah, but mom, he did something bad too. That's kind of the concept of unclean hands. And what exactly constitutes unclean hands? The court doesn't necessarily give us a bright line rule, but we do see that mom hiding the kids from dad was definitely mom having unclean hands. So here's another case I chose, Parker v. Parker in re Albert. This is a case with a long fact pattern to go through. In this case, mother and father were married and had 2 children. They were divorced in 1990. The court awarded mother and father joint legal custody and mother primary physical custody of the children. The visitation order was for father to see the children at reasonable times for reasonable periods, including 3 weekends per month. Father was ordered to pay child support of $137 per month per child for a total of $274 per month. In August of 2007, father filed a request for a judicial determination on arrears. Father stated that DCSS, which is also called the department, was trying to collect $83,629.58 in child support arrears from him. Father claimed that the children lived with him from February of 1993 until the children turned 18, and that he got no child support from mother. Father asked the family court to find that because he was the sole provider of the children for most of their lives, father didn't owe child support arrears. Father essentially asked for Jackson, aka Trey Naughty credits, for having custody of the children. There's a video on this channel about Jackson credits. In this case, they call them Trey Naughty credits. They're the same thing. Trey Naughty is another case. So DCSS basically agreed that father should get Jackson or Trey Naughty credits because the children lived with him and that he would owe no child support arrears. So then back to what the parties claimed actually happened. Father claimed, and this was to the family court that they claimed this, father claimed that mother called parental grandparents and told them that father could have custody of the children. Mother and the children lived in Texas and father lived in Oregon. Father further claimed that he borrowed money from his parents to fly to Texas to go get the children from mother. Father told mother he was taking the children to Oregon. They did not discuss the airfare. Father and the children flew to Oregon, and the children lived with father from that point forward. Mother disagreed with father's take on the situation. Mother stated that when she and the children moved to Texas, she didn't know how to contact father. She tried going to his house in California, but he'd moved. And while unpacking in Texas, mother found the contact information for parental grandparents, so father's parents. Mother called parental grandparents and gave them her contact information in Texas. When father came to Texas to take the children, mother thought they were just going to visit parental grandparents for a month in Canada and would return to her custody. Mother stated that she didn't know father lived in Oregon. Mother believed the children were supposed to return in early May. When father didn't return the children, mother contacted paternal grandparents, and paternal grandparents told her not to contact them again. Mother filed a foreign judgment in August of 1994, but mother didn't know where father was, so she was unable to pursue any further action. Father disagreed with mother's take on the situation. Father further claimed that the visit was for an undetermined length and that mother called him in Oregon and asked him if he was going to return the children to Texas. Father stated that he had to borrow money to get the children from Texas and he couldn't afford to return them to Texas. Father offered to return the children if mother could pay for part of the cost. Father claimed mother never contacted him again. Mother stated that she didn't remember having a phone conversation with father after the children went with father. Mother said she did not contact the court about regaining physical custody of the children because she tried to work with other agencies. Mother explained that she had even contacted America's Most Wanted about the case. The family court believed that mother and father had the family court believed mother, and they did not believe father, and found that father extorted these children and kept them from mother, even though she had been the parent granted custody. He conditioned the return on her paying for the travel expenses, which was not something that was discussed, nor is a condition of the judgment. The court said for those reasons, this motion, which is being treated as a motion for Trainati credits, is denied. There will be no Trainati credits in this matter. The family court explained father wrongfully kept these children from mother, and father was required to pay the child support arrears. And part of those arrears were actually owed to the state, and part of them were owed to mom. In December 2014, father filed a request for an order, 1, requiring the department, aka DCSS, to prepare an accounting of the child support arrears owed by father, and 2, awarding father Trainati credits. Father claimed in his attached declaration that mother was dishonest at the 2007 hearing, and he claimed that he acquired evidence showing that mother knew as early as 1991 that father lived in Oregon. So here father is trying to take another bite at the apple, so to speak. Relevant to this discussion, father alleged that mother had unclean hands because she was dishonest in court in 2007, that she shouldn't get any more child support payments because of those unclean hands, and that Laches barred DCSS from collecting any more child support arrears from him. Father stated that DCSS didn't try collecting the support payment from 1991 through 2008, and that it was unjust for DCSS to collect a debt after 16 years of failing to act. DCSS asserted the family court in 2007 determined the veracity of mother's statements, so that issue had already been decided. Alternatively, the department contended father was not diligent in seeking relief from the 2007 order. DCSS also argued that father had unclean hands because he wrongfully took the children to Oregon. Next, the department contended Laches did not apply because most of the arrears were owed to mother and not the department, and the department had been trying to collect arrears from father since 2008. The court found that father's request for Trainati credits was barred by res judicata because it was already litigated, and that Laches did not apply to the arrears owed to the department because the department had been making efforts to collect from father since 2008. Relevant to this Laches discussion, the issue to be resolved is if the family to court stumbling again. Relevant to this Laches discussion, the issue to be resolved is if the family court erred by not applying the doctrine of Laches to discharge the arrears owed to the department. The court affirmed the judgment of the family court. So basically, the court said that the family court issued a good ruling. The court held Laches is based on the principle that those who neglect their rights may be barred. The doctrine of Laches is to actions in equity what a statute of limitations is to actions in law, and that's Corona Properties of Florida, Inc. versus Monroe County. In an action to enforce a judgment for child support, the defendant may raise, and the court may consider the defense of Laches only with respect to any portion of the judgment that is owed to the state. And that's, of course, Family Code Section 291, Subdivision D. The court also held Laches may be used only as a shield, not as a sword, and that's La Prada versus Rosinski, Coronado Properties of Florida versus Monroe County. Father was the party seeking a remedy in the family court, therefore he can't assert the Laches defense. The court further held to the extent a petitioner can assert the defense of Laches to obtain relief, we conclude the family court did not err. The defendant must demonstrate 3 elements to successfully assert a Laches defense. 1, delay in asserting a right or a claim. 2, the delay was not reasonable or excusable. 3, prejudice. And again, this is Magic Kitchen LLC versus Good Things International Ltd. So father bore the burden of proving that Laches applied, and this is Highland Springs Conference and Training Center versus City of Banning. The court held that there was no delay in getting an order for father to pay child support because the child support order was entered in February of 1990 when the parties divorced. Mother received public assistance, and because of this, DCSS could be reimbursed for the public assistance from father's child support payments, and DCSS was actually required to enforce the child support order. So DCSS tried enforcing the child support order through an order to show cause for contempt as early as 1991, but ultimately couldn't follow through with this order to show cause because DCSS could not get father served. Therefore, the court held there was a delay in enforcing the child support order. However, it appears the delay was not because DCSS failed to act. The court held that father needed to show that he was prejudiced by DCSS's alleged delay in enforcing the child support order. And father alleged that the prejudice he suffered was the excessive interest that accrued on the arrears. A declaration by father reflects that he chose to stop paying child support in August of 1990 because father chose not to pay his court-ordered child support. Interest accrued. The accrual of interest is due to father's inactions, not the department's. Therefore, any interest father must pay is self-imposed. The evidence reflects that the interest payments resulted from father's decision to stop making child support payments. The court held that any prejudice did not result from the delay by the department, aka DCSS, and then the court affirmed the judgment of the family court. So there you go. That's Laches as a defense to paying child support to the other parent. And quickly, Laches is a defense to those child support arrears owed to the state. So for that time period that the parent was on public assistance. But as we see, it's not a defense to paying child support arrears to the other parent or child support to the other parent. But interestingly, the court can consider unclean hands and use its broad discretion to not enforce child support arrears. So there is still a way for a party to get equity, but they have to come to the court with clean hands. So there you go. Thank you for tuning in. Again, this was not legal advice. This was for educational purposes only. Go ahead, like the video, subscribe, ding the bell so that you get notifications when we upload future content. And go ahead, let us know if you'd like to hear any other topics covered. You can leave those in the comments. Drop us a comment about the video if you'd like as well. Those comments often find themselves in future videos, and if you have any questions, you can leave those in the comments. The answers will not be legal advice, but they make for good conversation. Thank you and take care.